Catherine, welcome to our Facebook Live. I'm so glad you could be here.
Thank you so much, Rick. It's my pleasure. I'm looking forward to it.
All right, well, I want to do a quick little intro for you. So this is Catherine Cavella, and she is a senior trademark and copyright attorney. She also does licensing and contracts and internet law, which internet law has got to be like blowing up right now, isn't it?
It is.
Um, so you've got 25 years of experience practicing business and IP law, and you've got a wealth of experience to help businesses navigate trademark, copyright, patent, and contract issues to maximize the return on their investment in innovation. She regularly advises and assists clients with contract, corporate, IP, and domain issues. Catherine has obtained over 1,000 trademark registrations. Okay, that's huge. For clients, including product design and trademark registrations, and has worked with hundreds of inventors and numerous patent attorneys on utility patents in fields ranging from software to chemical processes. Okay, that's really impressive. So, all right, this is one of the things that I love about you, that like you're just different. So you have a bachelor degree in cello performance.
I do.
From Cal State, and then you went to Loyola in LA for law school.
That's right. Yes. LA native.
You founded Cavella Law Group and IP Works.
That's right.
And all right, so I just have to do a little plug here. and a disclosure. So for everybody watching, Catherine is my intellectual property attorney. And so she's gotten a number of trademarks for me. And one of the things that I loved about you, Catherine, when we first started working together, like, I don't know, 7 years ago?
Yes.
A long time ago.
Long time ago.
You pushed me in a good way to think about things that I had never thought about. You're like, what about this? And what about that? And my response was, I'm not doing that. I'm not doing that. I don't need that. And you're like, I really think you do. And I've been so grateful over the years, because all of a sudden I'll start doing something and I'm like, I own this phrase in this world.
Isn't that nice?
It really is. And I love that you think through that. But I want to kind of back up a little bit. I came to you because I knew I needed a trademark. So I don't think that everybody knows that. So what's the number one misconception that businesses have about trademarks?
Well, that probably is, you sort of led into it very nicely there. I think the number one misconception I run across that businesses have about trademarks is either that they don't have any, or they don't need any, or, you know, they're just sort of invisible. They don't know what they are, but mostly that they don't, this is not something they need to be concerned about, or they don't have any. You know, they may think if they don't have some kind of fancy logo, they don't have trademark, because a lot of people equate it with a logo. But that is not at all the case. Every business has a trademark, has at least one, probably many, many. And so the more they understand what their trademarks are, the better they are able to just do a couple of little things that they do. If they do them early, they get huge payoff over time. They just keep getting more valuable. So that's why I like to have these conversations and get out there on Facebook Live and talk to people about it.
All right. So can you tell me what some of those things are that they should do?
Yes. So,
or is that a deeper conversation?
Well, for each individual company, it is a deeper conversation because everyone's different. You know, if there was a rubber stamp solution to what you do and what I do, then we wouldn't need to be here. But just as you customize everything to whoever you're working with, it's the same thing with trademarks. Everyone is different. Everyone has different needs, different goals, and different, you know, marks. But one of the sort of easy no-brainer ones is registering your trademarks early, especially and even before that, understanding what your key trademarks are. You really want to make sure that you know what your key trademarks are, so that you can file and register them early. And when I say register, I mean with the USPTO. So we can talk more about that if you want, but that's, doing that, it's a small investment if you do it early. If you don't do it, it can cost you hundreds of thousands in legal fees, and end up just making you have to shut down a brand that you've been using for 10 years and transition to something new, which is a painful prospect that's easily avoided if you just be proactive, like think ahead,
Practice.
file early, don't wait until it's an emergency. Do it early when you first start launching a brand.
Okay, so it sounds like you think that every brand should have a trademark, should be
At least one, yes. And it might help if I explain what trademarks are so that people know, can connect it to something in their own business. What a trademark is not a logo. It is anything that your customers use to recognize you or understand that something comes from you. So like Brooke, Cathedral Capital has fantastic branding. You've got a whole bunch of, other things that brands that you use, that people now, when they hear that, they hear 6 key numbers. They know, that's Brooke, that's Cathedral Capital. So any of those things that your customers look to recognize your services or your goods in the market, that those things are your trademarks. Whether they're key is, up to you. That's a case by case thing, like whether they're important enough to spend money on. If it's a slogan you're using for, one event and you're never going to come back to it again, yeah, maybe you don't need to protect that. Not necessary. But if it's the name of your company, like if it's your main brand, if it's the thing that you're out there spending tens of thousands of dollars promoting, probably a good idea to make sure that there isn't someone else out there using something that's really similar, or someone that comes along tomorrow and files an application to register a US trademark in it. That's where the expensive trouble can really start. So
All right, well, so let's talk about a brand and a slogan that's really famous. Like, I don't know, Nike comes to mind.
yeah, Nike's
Just do it.
Sure, absolutely.
They own Just Do It. And
They do.
that's not the logo, that's the phrase. And
That's right. Yeah,
so
so Nike's a great example. So if you look just at Nike and the things that we all know off the top of our heads, which because they're famous, they have spent a lot of money making us know all of their, probably not all of their trademarks, but the main things that everyone thinks of when you think of Nike. First of all, there's Nike. We all know what that is. We know that it's an athletic wear company, and now they make all kinds of other sports related things. They license their trademark to all kinds of things, but they represent a particular brand promise, which is, it's success and achievement oriented athletes. It's like believe in yourself, work hard, and like enjoy the payoff. It's this very success in athletics. That's what they stand for. So Just Do It connects with their whole brand vision. And that's really the other thing, is it's not just a catchy word, it's having a brand vision and a clear concept of what that brand means, so that all of your trademarks sort of fit. Ideally, that's what branding people do, and that's where trademark law comes in, because we can help clear and protect all those things. And they're worth something because they all connect to that brand promise. So they have Just Do It, they have the swoosh, they have Nike. They have, I'm sure, a million other things, but those are just the ones we all know. Each one of those is a trademark.
yeah, well, and so you're talking about the brand promise, and that really is the last couple that we have done together for my company. It's from panic to profit. That is our brand promise. That's what we do. We take businesses from a state of panic to a state of profit.
Absolutely. Yeah, I wasn't sure if you were going to, like, if you wanted me to talk about that brand, I was going to mention it. But absolutely, Panic to Profit is an excellent example of a trademark for Cathedral Capital, because it does connect very directly with your brand promise. And that's the ideal thing that your trademarks can and should do, is really communicate that to your customers. And then they start looking for that. And when they see Panic to Profit, they just immediately know, oh yeah, that's Cathedral Capital.
Yeah.
So that's the value. Yes, I know.
So, all right. So I want to change a little bit.
Sure.
because you see all kinds of different things in
Mhm.
intellectual property. And like, if you looked at the cover of my book right now, there are multiple different marks. There's
Mhm.
that little R with the circle around it, which I think is called an R ball, maybe. Is that
Yeah,
right?
I like R ball. I call it encircled R. R ball's way catchier.
Oh,
I'm gonna
well,
take
okay.
that.
And then there's that little TM.
Right.
What's the difference between those?
That's an excellent question. Yeah, and that's an often another misunderstood thing and a sense of anxiety. Really simple. The TM is any trademark. So I guess in order to make this make sense, do have to back up and say one thing, which is that trademarks you get trademarks when you start using trademarks in commerce. So if you have something that your customers that's capable of saying, hey, this is IP Works, this is Cathedral Capital, and you put it out there and you start using it marketing things in connection with your goods and services, then you are starting to develop trademark rights automatically. You don't need to file anything. You don't need to talk to a lawyer. You're automatically building trademark rights. This is why most businesses, they have trademarks, whether
Whoa,
they
whoa,
know
whoa.
it.
Let me
Yeah.
get this straight.
Mhm.
I can take anything and put that little TM on it without even notifying the USPTO.
Absolutely.
Which, let me define USPTO, United States Patent and Trademark Office. Like,
Correct.
I can just do it. Like,
Yes,
I
and
can
you
go
should.
Nike on this.
Well, yeah. Yes. So Nike, if you look closely, they have R's. They spend the money on the R balls.
But I can
Um,
just do it, right? I
you can
can
just,
just
oh,
put
yes, yes, yes.
I can just
Didn't
put
get it.
I can put the TM on.
You can just do it. Absolutely. Put the TM on. So right now, anyone who's watching this who has a company who has, like these are the things that we don't want someone else to know. And by the way, that's the gut check. If you're not sure what your trademarks are, go through all the different slogans and color schemes or logos or whatever it is that you're using and do the gut check of how much do I care if I see someone in one of my competitors using this or someone in a similar business using this? Does it make me go, oh my God? Or is it like, eh? So if it's an, oh my God, then that's a trademark and put a TM after it. And actually then also seriously consider filing a trademark application in the USPTO because yeah, sooner rather than later. Every day that passes, someone else could be filing something that will block you from being able to register it. And it's first come, first served, and they never expire as long as you can keep renewing them forever. It's not like a patent where you get a maximum of 20 years. With a trademark registration, you get it forever as long as you're using it.
As
So
long as you keep your as long as you keep using it, as long as you keep up
yeah,
the
and
paperwork.
right, every 10 years you have to file a renewal proving that you're still using it. And that's just so that they don't keep things on the books that no one's using anymore, because the rights come from use, not registration. And that's a
Holy cow.
really,
Whoa, whoa,
yeah,
whoa, whoa. Catherine, apparently
yes,
we've been working together for 10 years because we're in the process of renewing.
that's right.
Wow.
Yes. Oh, that's right. Well, there is a first 5 year. We might be in the 5 to 6 year,
Oh,
but
okay.
yeah, it might be. Yeah. After that one, because a lot of companies, they what they have found is that a lot of people that file trademark or businesses that file trademark applications, they don't last the first 10 years. They just abandon the trademark in the first 10 years. So they to a first attempt to clear the books at 5 years.
5 years. Oh, okay.
So that's the only little caveat there. But once you're past that, it's every 10
Every
years.
10 years.
Yeah.
Okay. So let's go back to the TM. Anybody can use, you can put it on anything. It's a use mark, not a filing mark.
That's right. Exactly.
And you should put it on anything that when you ask yourself, how much am I going to care if somebody else is using this? And you go, oh, it needs a TM.
Yes,
So,
absolutely.
all right. So you've got the TM. Well, what's the R ball?
Great segue. The R ball is once, let's say you slap the TM on there and then you file your application to register your trademark claim in the US Patent Trademark Office, uspto.gov. And then you'll pay some filing fees, and then there's a process, and it takes anywhere from 6 months to a year or more, usually around 6 months. And then when you're through that whole process, you get a certificate of registration, and you are officially RBAL, you're officially registered. At that point, all those TMs for that particular trademark will turn to R. I mean, you have to obviously make them. They're not going to magically turn to R. You have to do it. And I
Hey,
can't tell you how many people never switch to R, but yeah.
what's the benefit of going through the filing process?
Boy, is that a great one. That is the million-dollar question here. So the benefits are multifold. So I'll hit on sort of the main ones. One of the big benefits that doesn't get talked about much at all is that from the minute you file, let's say you and I were going to file a new trademark tomorrow. And what is tomorrow? The 7th? Is that right? Okay, the 7th of November.
Yeah, today's the 6th.
Today's the 6th. Yeah. All right. So what that means is once we file that, you have national priority on that trademark for the sphere that you're using it in, that you're claiming, starting from November 7th of 2020, starting from tomorrow. Even if you're not even using it yet, when you eventually get it registered, your claim rights, your priority, your exclusive right to that trademark goes all the way back to 2020. Even if it's not registered till 2022 for some reason, you get to go all the way back to 2020 to claim priority. And that's really important because what sometimes happens, and I've seen it happen too much, let's say we file that application tomorrow, and then in 2 weeks, someone in Idaho happens to come up with a very similar mark, whatever it is, and they start using it. And they build up a big following, a big customer loyalty in their neck of the woods. Maybe you're not even using it yet. Maybe you're launching a new product and you're still developing it, and you end up using it, starting it next year. But we filed the application in 2020. What ends up happening is eventually, let's say you discover them. They've now are known throughout Idaho and maybe Washington. And you decide obviously this is not going to work. You can't have someone using your brand out in another part of the country for something that you don't have any control over. That is not a that's not a good situation. Right. So you have to stop them. And at least that's what I would recommend as your trademark lawyer. And so in that situation, because you have filing rights going back to 2020, because you filed early, and they started after you filed, you can force them to stop. Like there's really no defense for them because they're supposed to search and see if the name is available before they start using it. And if they don't search, that's on them, that's not on you. So what it means is for the cost of a letter or a phone call, you can force them to stop using that name. Even better, if they do the searching, let's say they come up with it and then they decide to look, or they hire a lawyer to look, or their friend who knows about this, it comes up. The USPTO trademark database is crawled by all kinds of things. So if you do a Google search, you're probably going to find someone's trademark if it's exactly the same thing. And if they want to, and especially what I recommend is that they hire, that they would hire someone who knows how to do a trademark search to do a real trademark search. Because if it's not a direct hit, it could still be a problem and a computer won't find it. But in any case, if they do their searching that they're supposed to do and they find your application, whoever's doing that search goes back to them and says, I'm really sorry, but this is not clear to use. There's someone else using it, or they're planning on using it. And you will, if they get registered, you're out of luck. So I recommend you really pick a different name. And I do these all the time for people. And I do have to communicate that sometimes. And
this is not free and clear for you to use.
No, it's not. Exactly. This is not free and clear for you to use. And if you take a chance, just be aware that someone could come back, this person could come back and shut you down, and you will have no defense. There's really nothing you can do.
They could kind of hold you hostage and say, you can use this if you pay me an obscene amount of money.
Yes, they could do that. In the realities of, the legalities around that are actually a little more complicated because there's a quality control aspect to any kind of a license agreement. And it also, if you think about it as the brand owner, even if it's an
Oh, I
obscene
wouldn't
amount of
want
money. Exactly, you wouldn't want them to,
And
because
I
you
don't
can't
want them to
get
do that.
quality.
I don't know. If it was a really obscene amount of money, I
Maybe.
might let go a brand that I'm not really
That's
using.
true. Well, that's true. Actually, that's an excellent point. What you could do at that point is say, you know what, you can buy it. You can
Yeah,
buy it for $2 million. It's yours.
have at it.
Yeah.
All right, so I want to go back to two things. One,
Yeah.
you said you have national priority from the day of filing. So one of my trademarks had somebody using it before, and they used it in one specific, they used my phrase in one specific item.
Mhm.
They didn't trademark it. They weren't doing anything about it. Um, and they can continue to use it in that one small area where
If
they
they
did,
were before, yeah, if they
because
were
they were
before your,
before.
exactly. So if they were before your use and before your filing date, or
Right.
just before
Now,
your filing date.
they
Yeah,
can't expand,
right.
but they can
Exactly.
stay in that one narrow thing.
But they can stay, yeah. So you get to stop. I mean, this is free. You will never know how many people were blocked by your trademark application that's just sitting there. It's
Yeah,
great. Like, how fantastic is that? You pay them $225 and you get like an automatic block on a whole bunch of competition you never have to deal with.
there you go. All right, so you said there were multiple benefits of
Yeah,
registration. So the first one is that you get national
national
priority from
priority.
day of
Yeah.
filing.
Right,
What's the
which gives you
second one?
passive, right. So the national priority gives you passive protection as well as a, like a nice, it gives you, it's a sword and a shield, I like to say, so the sword is you going after the Idaho guy. The passive protection, the shield is, it's just sitting there for people to discover. And by the
Oh,
way, trademark examiners, if someone files this application and an examiner thinks that it's too similar, the examiner is going to do your defense for you and not allow that competing thing to be registered. So that's,
isn't that nice?
yeah, isn't that great? Government
Those are your
dollars.
government dollars at work there.
Yes, exactly. Let's do it. So that's, I mean, that's sort of several benefits in one, that national priority. Another one is that once you get registered, you then have a pretty solid claim on that trademark. It's sort of like the national priority gets kicked up a notch. It's because at that point, if someone does decide that they're going to ignore your trademark, maybe they didn't look it up at all. Maybe they did and they said, I'm going to take my chances, which sometimes people do. When you send them a letter with a certificate of registration, then they take it to me, someone like me, who says, you know what, you cannot win against these people. Just, you're going to have to cut your losses, apologize, and try to get out of this as gracefully with as little money as possible. Because it's just, there is no, unless it's not very close or there's some kind of argument that can be made,
Mhm.
it's just not worth it. It's such an easy lawsuit for you to win as the registered trademark owner and for them to lose,
Yeah.
if it's close enough to be a real problem. The only time they spend money on is when it's not so close, and so you have people disagreeing on whether it's a conflict, and that doesn't happen that much.
So just like in any litigation, there are damages, right?
That's right. That's right.
So if you can prove that they have damaged your reputation or anything in any way, they got to pay up.
Yes, so that's the other thing. In a situation where you have an intentional infringer, or, and you have maybe yeah, someone's been bad. Actually, that's another thing. Sometimes people use your trademark in there's sort of there's trademark infringement, and then there's all these unfair competition things that go with it. And when you have a registered trademark, it gives you like extra special standing to complain about some of these things. But yeah, exactly, there's damages. So even if they're just using your trademark innocently, if they don't stop when you've warned them, from that point forward, they're considered an intentional infringer, unless, in a worst case scenario, like it depends, of course, on how close it is, because they might have a legit argument that it's not a conflict. But in a case where it's a really direct conflict, I know lawyers always have to
I
couch
was going
everything.
to say, you used the lawyer phrase.
I know, I know.
Depends.
Well, there's always a case where, but in general, the point that you're making is a good one, which is that, if you say, well, you know what, I'm just going to use your trademark, big deal. what are you going to
Yeah.
do about it?
What are you going to do about it?
Yeah,
I'm going to sue your
yeah,
tuchus and
exactly.
I'm going to win.
And I'm going to win, and you're going to spend $100,000 in legal fees, and then you're going to pay me, $1.5 million in, or whatever the
Whatever
damages.
the damages are. Oh, and you're going to have to pay my attorney's fees.
And many times that, yes. So that's the other
So
thing. There
a
are
hundred
special,
thousand of yours, 100,000 of mine, plus 1.5 million, because we just randomly pulled all of these numbers out of the air.
yes, of course. But I mean,
1.7 million, that's expensive.
yes, it can really add up. So in real life, almost never comes to that, because they will go to a lawyer who's going to paint that picture for them and say, you can't win this. Just stop while you're ahead. Get out as quickly and easily as you can and apologize and pick a different trademark. And I'm sorry you've been using that for 20 years, but you should have filed your trademark application back then, and then you would have won. And I unfortunately have had this conversation with too many people,
Oh,
and it's, I feel bad for them, but there's no, unless you have a time machine, you can find yourself stuck in a corner with nowhere to go. So
yeah.
file early. That's the moral. Okay, so that's another
File
benefit.
early and file often,
And
right?
file often. Yes, yes. Do that gut check exercise. Do it from time to time. If you're a company that creates a lot of branding,
Mhm.
just train yourself to do at least a quarterly review of what you're using, and go through and see if you're covered. And I have a little spreadsheet I use, that I send to clients, just to try to, in fact, I should send you one. I probably haven't for you, but you're due. I think we should do one, which is an IP spreadsheet, which is like, here's what I have. Because the problem with intellectual property, and trademarks are, part of intellectual property,
Yeah.
is that it's abstract. So it's kind of not in people's minds. It's just sort of out there. Um, and like, it doesn't actually, a lot of the stuff has no book value until you sell. It's off
Right.
book value. So like, that's the other thing, the other big payoff, just to sort of get to your question, what's another big benefit, is that off book value. When your trademarks are well protected, it is going to help your due diligence if you're selling your company or you're selling a business unit with branding around it, because you can show your buyers, look, I registered these before I was even using them. These are solid and easy to protect, and they have all this goodwill. The trademarks are the legal vessel that holds the value of the goodwill. And then many companies, probably most companies, that's a huge part of the value that the buyer is buying. That's why
Well,
you
yeah.
buy a going concern, right?
If somebody was buying Nike and
Right.
they
Think about
didn't
that.
get to buy the Just Do It or the swoosh,
Hmm.
Nike wouldn't have a lot of value.
That's right. And I have heard business brokers tell me these wonderful stories about really, really motivated buyers who backed out. I'm thinking of a particular restaurant in Philadelphia, which I think he told the story on the radio, but just in case it was in private, I'm not going to say who it is. But it was a particular well-known, well-loved restaurant in Pennsylvania here. And the deal fell apart because when it came down to it in due diligence, it came out that the seller, the brand, did not own nice, clear, protected trademark rights in one of the areas that the buyer needed. And the buyer was like,
Mhm.
like, just like you said, Brooke, without that, we don't want this, because that's why we're buying this brand. If we can't solidly rely on it in
Then
that market,
it's
it's
not
not worth
useful.
it. Right.
So I'm not at the moment, but I was in an angel investor group for a while, and there was this great company that came up, and we're looking at it, and I'm like 99% of the way to writing the check. And one of the guys popped up and said, we've got an IP problem.
Ugh.
And I loved this company and I wanted to invest and I wanted it to do well. And I'm like, we got to dig into that IP. I'm not going to touch it. And
Yeah.
ultimately, I didn't invest because I did not feel confident
Yeah. It happens all the
that they
time.
owned what we were buying.
Exactly. It happens all the time. I've seen it happen a million times. And it's why you do the due diligence before you buy
Yeah.
or invest,
Before
Um,
you go in there.
yeah,
Yeah.
exactly. And so the trademark, having like being able to produce trademark certificates for all your key brands, that's beautiful for an investor or a buyer to see. That just, it also communicates that you value your branding, that you take it seriously, that you invest in your own company with an unchaotic no plan, which everyone that you advise, Brooke, is a planner and they know what they're doing and they're intentional. Um,
I hope so.
yeah,
At
I hope
least
so
if
too.
they're not when they come to me, they
They
better be after a
they will
while.
be, exactly. And so it sort of just goes with that. It's communicating, that you take yourself seriously and you want to protect your value. So plus it's extra value that you literally are selling because those
Yeah,
brands are easy to protect. So
absolutely. Um, and we've kind of talked about this a little bit, but I want to go back to it. So if somebody copies your trademark,
mhm.
we've got the sword and the shield, right? So
Yes.
if they copy the trademark and they decide that they want to register it and they go to the USPTO and try to register, they're going to protect us and
Yeah.
say, no, no, you can't do that.
Yeah.
If we find that they're doing it, we can send a cease and desist letter. And if they don't, then we can litigate, right?
Yes, correct. That's how
Okay.
it usually works. Yeah.
Okay. Are there any other ways to protect your trademark without litigation?
That's a great question. Yeah. So most of the cases that there are a couple other things you could do. I will say that I've been doing this for now. It's actually over 25 years. It's almost 30 years. It'll
Oh
be
my gosh.
30. I know it'll be 30
Catherine, you
years.
don't look old enough.
Thank you. Well, hey, it's good lighting, I suppose. Yeah, 30 years in 2022. But yeah, so over that amount of time of doing this, I have seen a lot of different things happen. But it- I have very, very rarely seen a case go to actual litigation. It very rarely happens. It only happens when, like the one I'm thinking of, was a case where my client waited 10 years before he filed the application, and then he was trying to launch an e-commerce store, and it
Uh-huh.
turns out that after he came up with the name and started using it in his neck of the woods, it was like 5 or 10, well, probably 5 years after, there was a company in another part of the country that had started using a same name just out of coincidence.
Just
And they
happen.
overlapped. Yeah, it just happened. Yeah, and they sort of kept growing into each other's, like they both started out in different spheres and they both
Yeah.
grew, and and that's how they came across. So it was just one of those things. If he had filed early and especially thought proactively about what am I going to want 5 years from now,
Mhm.
3 years from now, 5 years from now, it's more than just what you want now. Think about like what you're going to need, because that's what happens.
Well, okay, let's talk about that because that's one of the things that I feel like really sets you apart from other IP attorneys. Like you don't just say, okay, you want to use this on marketing materials, done, out.
Right. Yeah.
Walk me through the process or walk everybody watching through the process. What are those questions that you ask? How do you kind of dig down to make sure that you're covering enough?
That's an excellent question. So I think part of it is, I like to start with an understanding of what the company's goals are, what the client's goals are, because it's not it's very easy to just look at the case and say, well, this is a trademark and it can be protected in this sphere. But what I'm really doing, I hope, is protecting, representing a client and trying to help realize their goals, helping to make their goals come true. So I need to understand what those goals are. And I think that's really where it starts, is just having a conversation. Usually where I start is I have a conversation with a client. Now, you and I had worked together, so I already sort of
Yeah.
had an idea about you. But if it's someone that I haven't met, or I'm just getting to know, I will have a conversation to understand, like, first of all, what are all the things that you do, and where do you see, and then I always ask the question, where do you see your business going in the next 1 year, 3 years, 5 years? And then like, what are some wish list items where you aren't sure you want to do, but maybe in the back of your mind? Because I want to get into that sort of more aspirational, I want to engage that part of and then this is why it's helpful when I'm talking to an entrepreneur or a founder, instead of just someone at a lower level who would have to say, I'll have to get back to you.
Like, I don't know.
Yeah, I have no idea. They'll tell me, right? So, which is fine too, but then there's a lot more back and forth. And then there also, we can end up veering off into directions or, missing opportunities. So I do prefer working with founders, so that we can have that conversation at the beginning, because then I can keep my ears open for things that you might say, which suggest, what, you just said something about doing a podcast, but we hadn't talked about that. So let's talk about it. Do you see yourself doing a podcast? Do you want to use this branding, or would you have a different branding for that? And to just really have a conversation with the client so that I understand their vision. And that's, I mean, it's not an answer that maybe, it's not like I have a magic list of questions.
Right.
But although I do actually, here's a magic question that I do use now that I think of it, is if I had a magic wand, what would you want? That's often how I get into the goals conversation with people who sort of are not not going there with me yet.
Right.
The magic wand question is useful.
But so trademarks, you get them for certain classes, right?
Yes, yeah.
And the classes are all different. So
yeah,
like I own some that enable me to use mine as a book title,
right,
in a series.
Yes, a series of books. Yes.
And you said that podcasts were one. What are some of those classes that are most common?
That's a great point. So there's actually, it's not even so much the class as the type of goods and services. So because the classes themselves are very weirdly arbitrary. So a podcast, if it's downloaded, is in class 9, and a podcast that's streamed is in class 41. Like, why would that be?
God, there's so many classes. I had no idea.
Yeah. It's really, they keep adding more classes, but
we keep adding technology. I mean,
that is true. And they keep breaking, like there was a time when websites were all in like a single class, and now like half of the classes are like web enabled things. But basically, there are classes for goods and classes for services, doesn't really matter. So, but it's not one of the things that's important, I think, for people to understand is you have to pay filing fees based on the class, but as far as your protection, it's not like you own the whole class and you don't get any other class. The protection and the way they work is way more wishy-washy than that. I mean, it's good because you get more than you pay for, really, because the protection you get is based on something called likelihood of confusion. And this may be a little bit in the weeds for this conversation, but
yeah, but it's good for me because I'm always interested. So like, I'm going with it.
Okay, good. Well, I have an analogy that makes it a little easier to understand. So when we file the application, part of the strategy of it, and this is why I want to have those conversations, is I want to craft the description of services. So we say like, here's the trademark we're claiming. And then we say, and this is what we're using it or planning to use it on. And so we have to describe the goods and services. And that's where the magic is. So whatever those words, and so we might, sometimes if people want to save money, I'll try and get them all in a few number of classes as possible. The way it works is that like if I've described streaming podcasts and streaming podcasts and downloadable podcasts, that would be 2 different classes. But basically the idea is it's podcasts and information and all that. In the each one of those classes of descriptions in a class is like a spotlight on a stage. So, and the description of the goods or services is like, if
an ambient light that kind of.
Right. So you have like the center of the spotlight is like, for instance, let's do a simple example and we'll just say a series of books. That's a great one. So a series of books, everyone knows what a book is, it's on paper. And that's how the trademark office says a series of books is a paper thing. It's classified in the class 16, which is for paper. If you want for a downloadable ebook, it's class 9. So it's the same thing, but you're paying in 2 classes. But what that means is you get 2 spotlights on the stage. And
Right. And you
so,
don't have to, if you're in a battle, it's easier to defend
yes, because you
than
have
saying,
illuminated more of the stage.
yeah,
Yeah, so that way, in reality, if you only had 16 and someone did a downloadable book, it's a book. And so you could enforce your class 16 against
they're
a
class
downloadable
9.
book. Yeah, they're class 9, exactly. It's not like you're limited to protection in class 16. You get the spotlight, whatever's illuminated in the spotlight. And when you start getting out into the edges of the spotlight, that's where you start getting arguments about, like, I don't agree with you. But like in the center of the spotlight, it's pretty clear.
There's no, well, in my approach, and part of it's working with you, how much of the stage can I illuminate?
Yes, exactly. That's where
I'm
I like
like,
to work with people.
bring it on. How
It,
many spotlights do we need?
exactly.
Because the additional classes aren't all that expensive.
That's right. It's $225 a class. And if it gives you another spotlight for something you're, rolling out all over the place, it could be very useful. You have to be able to support it with your use, but there are strategic ways to do this. Just like I said with the book, right? Like if you have it downloadable and on paper, you can get protection in 9 and 16. And
Yeah.
then you stream it, like a podcast, you stream it, you can get 41. So, and the fact is that in doing that, like in 41, you can say, what, I think I'll do in-person classes also. Like 41, you can put in webinars as well as streaming podcasts. It's like streaming services, streaming educational information.
Right.
But it's not just streaming, it's also in person. They haven't, one
They
day
haven't
maybe it
divided
won't
that
be.
up yet.
They haven't divided it up yet. It's just the services part. The only reason that books and downloadable books are different is because one is considered a computer thing and the other is considered paper. That's it. It's
Right.
totally old-fashioned arbitrary.
So, but if you get class, what's the streaming podcast?
41.
So in a conversation with you, you could get class 41. You could say, yes, I'm going to do a streaming podcast.
Yes.
And then later decide, you know what? I want to do in-person webinars on this. You're
Yes.
already covered.
Yes, exactly.
You already own that.
Especially if you've talked to me, because I will say, if you're going to do a webinar, do you see yourself doing an in-person class one day? Because if you do, let's make sure that we write that in. You're already paying for it. And, your class could be given in ways that are not limited to streaming and they fall within 41. So let's describe everything that you're going to be doing, right? As long as it's not like, yeah, maybe 10 years from now I'll do, maybe then we don't necessarily write it in. But this is where being a little more strategic minded, it gives you a lot more. You're exactly right. At that point, then when you start doing your live classes and conferences and things, it's covered. You've got it.
It's there. Yeah, that was one of the things that I loved when we started working together, was because, I talk about, you pushed me. You asked me those questions. Would you think about, would you ever? You're going to do this. Would you ever do that? And the educational materials and the webinars and the stuff like that at the time, I hadn't thought that far ahead in my business, but you did.
Yeah.
And so it's covered.
Yeah, isn't that great?
Yes.
And you used them. You needed them covered.
Do. Yes, absolutely.
So that's what I really enjoy doing. That's a fun part of my business.
Yeah. And you do like working with entrepreneurs. So
Yes.
tell me who your ideal client is. Tell me who you like to work with.
That's
and who benefits most
yeah.
from working with you.
I would say the people that are ideal clients that would benefit most would be entrepreneurs, founders, people who are, I work a lot with startups, especially if they are building brands, building brand heavy businesses. So some
Mhm.
businesses are more about, I'm selling widgets and I don't, care what the brand is so much. I mean, they should maybe, but, but especially some businesses are very brand oriented. And so entrepreneurs, founders of very brand oriented businesses, would have a lot to gain. And I love working with people like that. That's my favorite kinds of clients, creative entrepreneurs, um, with a focus on branding.
Awesome.
Yeah.
Okay, I'm going to do a quick recap,
Okay.
and then I'm going to let you kind of do some closing thoughts. So
Great.
while I'm recapping, you can have closing thoughts.
Perfect.
So I think the first thing we covered that was really um, impactful is that almost every company has intellectual property. The question is, are they protecting it or not?
Right.
Or protecting it or not? And the way to figure out if it's something that should be protected is to do that gut check. If I
Mm-hmm.
saw somebody else using this, how would I feel?
Yeah.
So the more like it makes your heart stop, the more you should be calling Catherine.
Yes.
I think the next thing that I learned that was amazing is that you can put a TM on anything. You don't have to file. It doesn't cost anything. You
Yep.
just shove that. Like, dude, there's going to be a TM at the end of every one of my sentences, practically.
Good.
So, like, I love that. The benefits of registering. So once we've decided that we need to own this really, and not just do the TM,
Yeah.
um, the benefits of registration are the sword and the shield.
Yes.
So the shield is from the day you own it, if anybody else tries to, from the day you file, if
Mm-hmm.
anybody else tries to, buy it, own it, register it,
Mm-hmm.
the patent office is going to push them off. You don't
Yeah.
have to do anything. It's
Right.
already done.
Isn't that great?
It's fabulous. And then the sword part is if someone is using your trademark, your registered trademark, you send a cease and desist letter, and if they don't stop, you can actually litigate that. Though
Absolutely.
generally you're not going to have to,
Right.
because unless they get a really dumb attorney, their
Yeah,
attorney's going to say you don't have a case.
that's right.
And then the other thing I really liked is talking about the different classes and the like and how you decide what you need to do. And I really do, I've said it before, I'll say it again. That's your secret sauce, Catherine. That's what really sets you apart. And
Thank
it's
you.
that conversation that you have and getting to know the client and understanding exactly what they do,
Mm-hmm.
and then pushing them and asking where their business is going and talking about their wish list. And that is amazing. And then the last thing is that every trademark class that you do, so one trademark has multiple classes.
Right.
Every class you do is like a spotlight on the stage. So the idea is to illuminate as much of the stage as possible.
Absolutely. Yeah, absolutely. Why not? Why
Might
not?
as well. It
Yeah, you're
costs
promoting the brand.
$225.
Right, exactly. And then it's easy enough if you know what you're doing to then support those marks, and that can really help. It can help like in multiple ways, because I mean, maybe you might have put off doing some of these things later, except that you already had trademark rights pending in them, and you're like, I might as well, because
Might as well do it.
yeah, might as well do it. So
Awesome.
knowing you would have done it anyway, but
I probably would have. So, but now it's protected.
yes.
So,
Yeah.
all right. Closing thoughts. Anything you want
Closing
people to
thoughts.
know?
Um, Boy, you summarized us so many of my what would have been my closing thoughts.
I took notes.
It's so great. That's wonderful. Just, I'm just so really grateful, Brooke, to have the opportunity to talk to your followers and whoever's listening, just to spread the word that trademarks are a lot of bang for a little bit of investment. A lot of bang for the buck, a lot of return on a small investment for any business that is planning on growing, you know, and wants to grow without having to change names every 5 years or so. Um,
Absolutely.
it's a great return on investment. It's just to throw out numbers, as of 2020, you know, the filing fees are cheap, the renewal fees are cheap. The filing fees 225 a class. Renewal fees are, you know, 325 or $600. Well, let me see what it is, 625. It gets a little more complicated at the 5 years, but in any case, it's under $1,000. These filing fees are under $1,000. The legal fees, even if you use someone like me who's very strategic, and I'm not, you know, trying to do a numbers thing and not, you know, I'm engaging so you get something valuable rather than just something that's easy and quick. It's still, we're talking a couple $1,000s. We're not talking $10,000. The payoff is tens of thousands, if not hundreds of thousands. So.
Okay, so you brought something up. I was wrapping this
Oh,
up. Now I'm not going to wrap
sorry.
this up. No, no, no.
Sorry.
You made me think of something
Hmm.
that I want to come back.
Okay.
I'm in a lot of Facebook groups. And every now and then I see someone saying, I need a trademark. I'm going to go to LegalZoom.
Oh, yes.
And
Right.
it makes me want to throw up.
Yes. Yes.
Can you talk about the difference a little
Yes.
bit
I
between
certainly
going to
can.
you and going to LegalZoom?
Yes, or going to any of the trademark mills. You know, there's LegalZoom, there's Trademarkia, there's, you know, the problem with those is that first of all, LegalZoom and Trademarkia, that kind of thing, you're not getting a lawyer. You're getting, like LegalZoom, all they do is they connect you to the uspto.gov. You can do it if you're going to do that. Save the couple $100s and just go to uspto.gov yourself, because you don't need them to go there, you know, and they're not giving you anything, you know.
They're not
They're
giving you any value. They're just
no, they're
redirecting.
not. Right. They're not having that conversation. The other thing is, like, most people, when they first start out, they don't actually understand what their trademark is, because one of the things we sort of glossed over is the goods and services. That's really strategic, and it's important how it's written and how they're grouped into these classes, because it affects how much you spend and also how much you get. So like, that's strategy, and LegalZoom doesn't do strategy. No one who's doing it for, you know, $50 or $100 or even $300 is going to spend time trying to figure out what strategy works for you.
No.
That's the important part, you know, because without the strategy, you could end up with something worthless. And I see this happen too often. And so that's the real thing, is the point of going to someone like me who will get to know you and understand what you need, is that you will actually get what you need. I'm thinking of a case, I know we're trying to wrap this up, but one of the problems is throwing everything into a single application. As far as the mark claim is important too, because well, without getting into the details, what you actually say, I'm registering this as my trademark, you may be wrong about what you are using. You may think you understand, but strategically, legally, what you're actually using may be slightly different. So things like punctuation and spaces.
And we had a problem with one of my trademarks.
Yeah, because
registered and done, and I put it on a book cover, and it changed it.
Changed it, right?
The layout of the book changed it.
Yes, that's right. And so there are these little things. In some ways, the protection and everything, it's very broad, but there are some ways where it's extremely picky. And this is where, if you're doing it yourself, which if you're using any of those mills, whether it's LegalZoom or someone else, you're probably doing it yourself. They say, tell me the trademark you want to register, and you type it in, and they go with what you typed in. I don't do that. I say, let me see what you're doing or planning on doing, and then I will tell you what I recommend you register. And it's very likely not what you think. The graphic elements, don't start with that unless you need them. There are very rare situations where the graphics are a good thing to add to the first mark, but probably they're not. And most people, that's another problem. They go straight with the graphic mark, and that's not actually strategically going to give them what they ought to have for their first registration. There's a million little things like that, which is the reason why, when you're, like, also just in general, if you're having someone do legal work for you and you can't look them in the eye in some way, maybe that's not such, for me, I
That's
like
important.
anyone that tells me what to do with my money or like advises me about the law. I want
Yeah,
to
you're
know
like,
this. Yeah, I want this to be a
I
human
want to see
being,
you.
right? Not a machine. Um, so anyway, I guess that's maybe an answer to your question.
I think it is.
Great question.
All right. So if somebody wants to get hold of you,
Yes.
if they've got a question about a trademark, how do they do that?
That is great. Thank you so much. Yes. So they can go to www.ipworkslaw.com. That's IP like invention protection. WORKS like Sam, LAW.com. That's my company, IP Works Law. And they can, contact me that way. There's also some information. Or you can just go to C. Cavella at IP Works Law. So that's my first initial and last name, CCA, V as in Victor, ELLA at IP Works Law. Either of those work great. You can find me on LinkedIn, Facebook,
You're
probably
everywhere.
link. Yeah, I'm all over the place. I'm easy to
Oh,
find. And I do free hangouts every 2 weeks on Thursdays. So
didn't know that. All
I
right. So
started,
tell
yeah.
me about the hangout. So you do a hangout and you what?
There's a different topic
You hang
every
out.
time. Yeah, and we hang out. Yeah, it's
You
just
hang
from
out.
11
Okay.
to noon. Yeah, they're online, of course. It's not an in-person thing. And it's just whoever wants to join. It is a sort of semi-private. It's invitation only, so you have to sign up. I mean, you have to get the link in the invitation to join. So it's not like I published the Zoom link. You have to register for the event and then you get the Zoom link. And we always have meeting notes afterwards. So it's sort of like, it's fun. It's fun. You
Good.
get to meet your fellow business owners and learn about a topic.
And there's a lot of value in that.
Thank you. I like doing them.
Awesome. All right,
Anyway,
Catherine, thank you so much for coming today. I really appreciate it.
my pleasure. Thank you, Brooke. It's always great to talk to you. And I hope this has been of value to somebody.
I think it has.
Great. Take care.
You too.